Hello? Okay, this is working. Hello, and good morning to everyone. First of all, I would like to thank Professor Attila Manihart and the ELTE Faculty of Law for the invitation to this conference, which contains a great cast addressing the key issues of the legal aspects of the intersection of blockchain, crypto assets, and law. I'm genuinely happy not only to be here in this historic university, 17th century if I'm not mistaken, but also as my first time in the wonderful city of Budapest, one of the most beautiful and exquisite of European capitals. For that, and I hope I do not butcher the pronunciation, köszönöm barátaim. My name is António Garcia Rolo, and I am indeed a guest lecturer and PhD candidate in the civil law, for civil law in the Faculty of Law of the University of Lisbon, a researcher in its Research Center for Private Law, and co-principal investigator of the research project Lisbon DAO Observatory. Since 2018, I've had the pleasure to being in this journey of researching the intersection between challenges brought by blockchain technology and crypto assets in civil and commercial law, both in papers and in academic events. I'm not just an academic, of course. I'm also currently working as a consultant in the blockchain consultancy firm BlockReg Advisors and in the trade association Digital Currencies Governance Group. But enough about me. Being in this first panel, especially with a suggestive title, In Media Res, is at the same time a challenge and an opportunity to put in evidence the intersection between crypto assets and, sorry, this is, okay, sorry. To put in evidence the intersection between crypto assets and traditional civil and commercial law. Indeed, one thing that has become really very evident for me in this past years researching and teaching on blockchain and crypto assets is that once you start looking at it, the hype kind of dies down in a way. Blockchain is indeed a novel technology with revolutionary potential. However, as the novelty starts to sink in, you move more from the age bracket of 15 to 35, more to the age bracket afterwards. So you start to realize something which is really essential, which is what is so special about crypto assets or tokens or any blockchain-based form of property or representation of rights and values. I will define, for the purposes of my presentation, I will adopt on purpose a very wide definition of crypto assets, digital assets, tokens. At the end of the day, potato, it's more or less the same thing. Of course, there's a whole history behind the different names chosen for the different representations of rights and values in the blockchain, but at the end of the day, we can all group all of them under the same category. And I would define them as digital representations of rights and obligations, or digital representations of values, now linking up with a previous presentation, whose specificity is only that its ownership and its transferability is determined through blockchain or another similar distributed ledger technology. And this is the key thing to keep in mind, because the only thing special about crypto assets or digital assets is the way the ownership and therefore the legitimacy to transfer them is determined. It is determined in a decentralized and distributed way, and in principle, in a distributed and immutable system called blockchain or any other similar DLT, which is no more, for legal purposes, than a private registry. For instance, if you buy a house, you go to the public, to the land registry to see, okay, who owns the house? It's person A owns the house. So person A has the legitimacy to transfer the house to person B. Blockchain, structurally, is not that different. The difference, of course, it's not a public registry. It's a private registry in the sense that it's not state-owned. Then, depending on the blockchain, some of them might be publicly available or not. But at the end of the day, this is a new form of registry. This is the main thing to keep in mind. Because content-wise, in many cases, there's nothing particularly new. It's more in the way to determine the ownership and the transferability. Of course, it opens a lot of substantive possibilities, but that's, I think, a point to keep in mind. And I would like to take the chance to talk about a specific way we can look at crypto assets. So I'm not going to present like a general overview of crypto assets and their categories and whatnot. I will present a an issue that basically it's a different way to look at them, which is very in vogue now, which is called tokenization. Its various meanings and forms, and its legal consequences. Once again, as I said, I'll be using token, crypto asset, and digital asset indistinguishably. And tokenization is just a different way to look at this crypto phenomenon. Instead of looking at it from the perspective of the a priori classification of function, whether the token is investment or whether it's utility, whether it's monetary, we look at it from the perspective of the real world or off-chain reality it seeks to represent. So basically, linking up with the previous presentation, which made excellent points on that, here there are a lot of crypto assets that can, as Mr. Party has said, they can just represent by themselves value and property, and of course, liable to represent property. Now, when I speak of tokenization, I speak about those crypto assets or tokens that seek to represent some a priori reality from the real world or something that we know. But in the end, this is not separate from, this is not a separate phenomenon from the wider crypto asset phenomenon. Oops, no. Okay. There it is. So, tokenization is often defined as the representation of financial or real-world assets in digital form, represented in a blockchain or another ELTE. And being represented in a blockchain can mean that the blockchain is the technology used, as I said, to determine the ownership and therefore the legitimacy of transfer of the tokenized asset. One can think of tokenization as a new form of representation of a legal relationship, of a bundle of rights or obligations of real-world assets, just as paper was an old form of representation or inscription of rights, such as those embedded in a traditional share or in a traditional bond, or the more recent registration in an account is also a liable and possible form to represent those bundle of rights. And tokenization of rights, obligations, and real-world assets has obvious advantages. Of course, it enables and makes more accessible the ownership of several assets, democratizes finance, and allows more people to access fast transfer of the underlying assets. In particular, for real-world assets that are usually very costly to acquire through traditional means, such as gold, for instance, it enables more people to access them through fractional ownership. It also allows for trustless transactions, of course, so that's a general advantage of blockchain, transactions less dependent on intermediaries, and less transaction fees. However, tokenization is not a straightforward phenomenon. You look at it, you'll read on social media, on publications, people talk about tokenization, and sometimes they're talking about different things, of course, related things, but different things. So, of course, we have to do a taxonomy naturally. It wouldn't be complete without a taxonomy. First of all, we have what it's called in the literature direct or native tokenization. Basically, the tokens or the crypto assets are the primary form of the asset representing legally enforceable acts. Here, one could include tokenized securities, such as tokenized shares or bonds, or, for instance, CBDC, so the central bank digital currencies. And those assets are particular in the fact that they are usually not represented in other forms. So the form of the token of the crypto asset, it's the primary and only form of representation. Then we have indirect tokenization, which can include a lot of things. Basically, here tokens represent rights on an intermediary structure controlling the assets and are backed by the original asset, in which one could include most instances of tokenized real estate, where tokenization is seldom or never, but we'll go to that, the primary form of representation, or tokenized treasury bills, for instance. One can think about this form of tokenization as kind of a continuation of the traditional securitization, where assets are usually pooled and repackaged into new forms of representation, but here it's enhanced by blockchain technology. For instance, many examples of supposedly tokenized real estate are basically indirect tokenization. Those are cases where you can have an SPV, which can own several plots of land, for instance, and its shares could be tokenized, or bonds that it issues can be tokenized. So in that sense, or a fund as well, could be also a good example. In that sense, it's an updated form of securitization, which already exists. And also we have the example of stablecoins, especially the commodity-backed stablecoins, which basically are crypto assets who purport to represent a certain value with reference to a given real-world commodity, gold, for instance, but usually, or I would say 99% of the cases, they do not represent native and direct ownership of that given asset. So when you see someone saying, oh, here's a stable coin, now you can own gold directly or a fraction of a gold bar, usually can't. You basically have a contractual relationship with the issuer in which the issuer says, I have the gold here, so basically if you have one of these gold-backed stablecoins, I will give you a certain value which is calculated according to the amount of gold that I have. So basically, it's more of a contractual relationship than a direct ownership. That's why it's indirect tokenization. Of course, the gold in reserve, it's still important in those cases, but it's not direct ownership over the gold or a fraction of the gold. So these two categories I would include as complete tokenization. And then there's a residual category, which would be incomplete tokenization, basically cases where tokens do not fully embody the legal rights of the underlying asset and serve as an instrument to share information, manage assets, or prove facts. This would be the case of the well-known mirroring assets, where the token is merely an information with limited legal value. It can facilitate the identification of ownership, but the claim is by law or by contract primarily represented in another system. So from these empirical categories, let's look at how some legal systems have approached tokenization. I will focus, legal frameworks that directly address complete tokenization, so the direct and indirect, are still very few and far between, but they seem to work in some identifiable ways, and I've been focusing mainly on securities. So the first group would be acknowledgement of tokenized securities, then bespoke tokenized security frameworks, and then more or less bespoke real-world asset tokenization frameworks. The first one is the most basic, but effortless form of approaching tokenization of securities. In this form, when legal frameworks look at crypto assets that represent security-like characteristics, usually known as investment or security tokens, they apply traditional securities law to those crypto assets. Here, tokenization per se does not have a legal framework, but tokenized securities are treated as something akin to register securities. That is the approach of MiCA, for instance. It's the default principle in the EU. So basically, in the absence of specific member state regulation, Article 2.4 of MiCA acknowledges that crypto assets that qualify as securities are securities under a principle of technological neutrality. It thus acknowledges direct tokenization of securities, though it does not provide a bespoke framework for them. Of course, we have the DLT pilot regime, which kind of develops this route by introducing this pilot regime for DLT market infrastructures, but it's still, it's a pilot regime, so it's not a transversal one. And let me stress that the absence of of such an acknowledgement would not, in theory, preclude crypto assets or tokens from being considered securities. Before MiCA said that, a crypto asset that had the characteristics of a security would be a security, period. Because it would be an atypical security, of course. Of course, then it depends whether certain legal systems acknowledge the existence of atypical securities or not. Some of them do, some of them don't. But most jurisdictions would consider it a security even before this direct acknowledgement. Then we have the bespoke direct tokenized securities frameworks. And actually, I'm going to repeat some of the things Mr. Party has already said, which is interesting to see how the presentations are related. So basically, I'm talking about legal acts and frameworks that directly address the procedural and legal aspects of the process of tokenization, be it direct or indirect, explicitly recognizing tokenized securities as a category of security representation in equal footing with paper-based and registry entry securities, with specific rules for transmission and determination of ownership and legitimacy to transfer and supervisory frameworks for the creation and management of the blockchains or DLT arrangements that underlie it. This tokenized form is usually admitted as the sole type of exclusive formal representation, though the tokens themselves, of course, might be subject to external events. And there are three good examples of major jurisdictions right here in the EU that take this approach: France, Germany, and Spain. In such jurisdictions, their securities laws have been modified to recognize tokens as primary forms of representation of securities alongside the traditional paper and registration forms, though they approach market infrastructure differently, and the regimes themselves, they are not exactly identical. Well, I won't develop further, not to repeat a lot, but as it is here in the slide, in France, the Monetary and Financial Code foresees direct tokenization and treats tokenized financial instruments as a standalone category, in par with paper instruments and registered instruments. In Germany, the Electronic Securities Act also allows for the issuance of electronic bearer financial instruments. So basically, you have two types of non-electronic, so non-paper securities, so electronic security registered in a central registry, and then a crypto security. Both of these regimes allow free conversion from paper to this category at the issuer's will. Of course, all of them also impose some requirements on the registries where the crypto securities are stored. So basically, this is an example of a bespoke regime for direct security tokenization. In Spain also, the new 2023 securities market law explicitly foresees tokenization. As it is a new law, it's interesting because in the French and in the German cases, they basically inserted these new categories into their existing laws, while here it was a new securities code, so to speak, so they just natively represented a tokenized form as a possible form. And the law clarifies that these financial instruments are issued, registered, and transferred or stored using DLT, or of which blockchain is the main example. So once again, very much like France and Germany, this is an example of a bespoke regime for direct tokenization of securities, as the securities are issued, registered, or stored using DLT are solely represented by their tokenized form and not by any other means. Having looked at these three regimes, what can we take from these legal approaches? Well, first of all, it is important to keep in mind that crypto assets usually, not necessarily always, but usually, represent some traditional legal relationship, be it an investment contract or a security, a service provision contract, in the case of utility tokens, or some contractual structure to provide a source of value, such as in stablecoins. So even in the absence of bespoke laws for crypto assets, they are still legally significant. They did not need MiCA's permission to exist. They existed self-sufficiently, well, with other laws being applicable to them, of course. That is clear. However, they were not exempt from being subject to the closest regime applicable through the filling of a lacuna. This is evident when talking about direct tokenization of securities, and indeed looking at tokenization both from an empirical point of view and from a legal point of view reveals something I alluded to in the introduction. A tokenized form is basically, in these cases, a new set of clothes. The content is the same. It's the classic security, be it a share, a bond, a fund unit. Just as these bundles of rights and obligations were traditionally represented in paper and in paper form, and in the late 20th century jumped to the possibility of having a registration in an account form, technological advances now allow them to give another technological jump to use DLT and blockchain as a technology to determine their ownership and therefore who has the legitimacy to transfer. So tokenized securities are as much things, in a legal sense, as registered or title securities, and can be firmly placed in the continental and civil law tradition of titles of credit as representations of more or less complex bundles of rights and of obligations. However, there is a more complicated thing other than tokenized securities, and this is the tokenization of real-world assets. So well, one could say, and that's what I just said, that tokenization of securities is a mere update of traditional securities law. One could argue that tokenization of real-world assets is where real legal innovation rests. This can be true conceptually, but empirically, it is a bit messier than that. Most laws of the continental civil law tradition would not preclude an indirect tokenization as a purely contractual arrangement. It's perfectly possible. There's nothing stopping that through the principle of private autonomy, though the token itself could be subject to existing crypto or securities laws. As I mentioned above, I see no legal obstacles in most jurisdictions to those structures that I spoke. For instance, an SPV owning real estate that issues tokenized securities, so that would be a form of indirect real estate tokenization, where the token would not represent primarily for instance, the plot of land, but rather the economic value or potential. And also stablecoins would be a good example. But direct tokenization of real-world physical assets, such as commodities, real estate, or movable property, would correspond to the case where the holder of a direct tokenization, of a direct tokenized real-world asset, would have an in rem right over such an asset and would be able to claim it directly, segregated from the remainder of the issuer's asset pool, contrarily, for instance, to stable coins or to tokenized SPVs. And this is legally more challenging and requires specific legal authorization and changes to basic civil and property law. This is why, in most cases, when you hear or you read about real-world tokenization, read a little bit better because it's usually indirect tokenization. So take with a grain of salt the claims that you will own a bar of gold directly or a piece of a house or something like that. Just let us look briefly at two jurisdictions that have attempted on very different ways to go down that route. First, one that's conceptually very interesting but empirically hasn't brought a lot, it's Liechtenstein. So basically, Liechtenstein is often heralded in many publications as a jurisdiction allowing and promoting the tokenization of real-world assets. And it's an interesting example because it's so close to us. It has a continental civil law legal system in the Roman Germanic tradition. And Liechtenstein's most relevant blockchain piece of legislation is the Token and Trusted Technology Service Provider Act of 2020, which does not contain an exactly bespoke regime for direct tokenization of physical assets, but is open enough that it creates what some people call the token container model. What do I mean by that? Its main provision says that tokens can represent claims or rights of membership against a person, rights to property, or other absolute or relative rights, excluding, of course, personality rights, which is natural. So it seems wide enough to include securities, property rights over commodities, and even real estate, theoretically. The fact that the definition ends with or other absolute or relative rights seems to indicate there is no apparent restriction on what can be tokenized except for personality rights, of course. This law is also different from any other crypto legislation as it starts with a civil law basis as its main focus. And as Mr. Partias said, any future transversal regime that allows tokenization and property and real property over tokens should start also by the basics and should start by civil law and not just, ad hoc laws. So instead of surgical changes to a financial legislation or standalone acts that conflict with existing laws, this act seemed to adopt an interesting approach. However, it does not displace mandatory civil law rules applying to property law, from what I know. So basically, on the one hand, it says you can tokenize any rights, including property rights, but on the other hand, for instance, if you're talking about a plot of land, you still have to go through the traditional channels of property law and registries. So conceptually very interesting, but in practice it hasn't created a lot, but it's an interesting start. But theoretically, this is a framework that allows for direct and indirect tokenization with its token container model, while not being as bespoke as the frameworks we saw above, but with no apparent restriction. Finally, usually it's a jurisdiction that has a lot of hype, sometimes too much, but usually Dubai is looked as a super friendly jurisdiction to tokenization, as its government's body incentivize and even partake in it, mostly in direct tokenization, of course. But you see a lot on social media and other specialty literature saying, oh, Dubai now allows tokenization of everything. Well, more or less. So basically what they did was, instead of enshrining most of their crypto framework in statutory law, Dubai has a general law, very small, short one, and then delegates everything in their authority, the Virtual Assets Regulatory Authority, VARA. And so basically the authority can do what it wants in its rulemaking, and basically it has recently issued a regulation, so a sub-legal text, saying basically that you can create what they call an asset reference virtual asset, which could include basically anything that represents direct, indirect, current, future, or contingent ownership of any real-world asset, or an entitlement to receive a share, or any other right. So basically, it's wide enough to include real estate, and they do like to make a lot of marketing around that. However, there is, contrary to the Liechtenstein rules, these rules subject the issuance of any token directly to the authorization of this authority. So basically, instead of having a general admissibility clause that says, okay, tokens can represent direct ownership over physical assets, it basically says, okay, you can ask this authority to create a token that will represent some real-world physical assets. So it's a different technique. So no general admissibility and wide discretion of the authority. But early this year, the Dubai Land Department said or alleged that it would be launching a pilot phase to integrate it, because these things, especially with real estate, if they're not integrated with public utilities and public registries, they empirically can mean very little. Finally, to conclude the presentation, and I'm sorry, I think I'm 5 minutes overdue, despite the promises of these real-world assets tokenization frameworks, my understanding is that they have not gained to date a lot of traction over indirect tokenization and resulted in mass adoption. And once again, what you'll see the most when talking about tokenization of real-world assets is indirect contractual tokenization, not direct. And direct tokenization of commodities in real estate might not even be beneficial for potential issuers. If I am an issuer, why would I prefer to issue a token representing a direct claim over a fraction of land or a bar of gold, instead of creating an internal structure which I control with a more contractual nature, already time and time tested in traditional securitization? It is riskier for the issuer to though, of course, it would be potential for the token holder. Many issuers still prefer to market indirect tokenization schemes as if they were direct, with vague language saying, oh, it's like owning a bar of gold, or it's like owning a plot of land, while then if you look at the fine print, it isn't. And direct tokenization of real estate in particular would require not only an overhaul of traditional property rights, but also of public registries, effective creating a parallel blockchain land registry, potentially for a portion of jurisdictions' real estate. And I find it hard to believe, but let's see, these things change quickly, that many jurisdictions, in that sense, I will turn 35 in December, so in this sense, I'm already anticipating to the 35 state of mind. I find it hard that many jurisdictions would give up the traditional monopoly that sovereign states have on the determination of the ownership of their land. In order to preserve that monopoly, such states would need to develop or to deploy a permissioned public blockchain fully controlled by themselves, which is often perceived as an anathema to the ideological underpinnings of blockchain, which is sort of anarcho-capitalist or libertarian in nature. We might continue, of course, to see pilot projects or vague announcements such as the Dubai Land Department or others, but a wider adoption of direct tokenization seems unlikely. It is difficult to see a sovereign state, giving up a core element of sovereignty to permissionless blockchains, and it's easier for issuers as well to create indirect and contractual tokenization schemes. So, at the end of the day, while those specific regimes are indeed innovative and out of the box, tokenization of real-world assets, and in particular real estate, requires deep changes to core tenets of civil and property law that, for now, I doubt that many sovereign states are ready for and willing to do. And that also do not seem to be of interest to an industry more interested in more flexible contractual arrangements for indirect tokenization, which are merely, once again, new clothes for old schemes of securitization, just as above, exactly the same. So tokenization real contribution may not be the reinvention of property law, but at least for now, it has been just the optimization of capital markets. Let's see where things go. Thank you so much.